So this is a talk that came out of mostly me and Laura reading the Act and discussing it, and us realizing, oh, there are so many things in the Act that nobody talks about that were so important to us. And I found myself basically giving rants about the Act to friends whenever the topic came up. I was like, okay, I could give this rant to an audience. Why not? The way it goes is that if you read the Act, you can read the PDF, which is a little bit harder to read, but then there is this website which has done a great job at categorizing different sections, having hyperlinks between different sections because there's a lot of citation between the different parts of the Act itself, and the recitals that give a little bit more context to the Act itself. The language is not too hard, but it does get some getting used to. And a part of this talk is me reading blurbs from the Act, partly for your ears and your eyes to get used to how the Act looks like. Okay. So you read the Act, or maybe maybe a lot of you, like us, before we started reading the Act, we were like, okay, we want to know what the Act is about. Surely there are a lot of great summaries out there. And we went out there and we tried to read the summaries. They do give you an idea, but you feel like the meat is not there. There's some things missing. And we started reading and we realized, yes, there's so much that is missed in those summaries. And some of those things are the topic of this talk. Okay, so what is the Act about? It is harmonized rules for the placing on the market, the putting into service, and the use of AI systems in the Union. So three things. You are placing on the market something, like an LLM maybe, putting into service, or you're using something that uses those things. It's about prohibitions of certain AI practices. We go through them that are just banned. Specific requirements for high-risk AI systems and obligations for operators of such systems. This is probably mostly what you hear about when you hear about the Act, the regulations that apply to such systems. And harmonized transparency rules for certain other AI systems, harmonized rules for the placing on the market of general-purpose AI models. You read some summaries and it feels like the Act is about general-purpose AI models, basically generative AI, LLMs, but that's not the case. All of that happened while the Act was being written, and then at some point they were like, oh, this is a new topic. We have to also take into account and address the issues that come with all these large models. And then rules on market monitoring, market surveillance, governance, and enforcement, measures to support innovation with a particular focus on small, medium, large enterprises, including startups. Okay, who does this apply to? You're in the EU market, your model is available in the EU, the output of an AI system using the model is available in the market, or you import the model or the system into the market. Or you represent an outside of market entity for their model in the AI system. Okay, good. But then there are exceptions to the whole Act. We will talk about some other exceptions to particular things about the Act, but this is the whole Act. This regulation shall not in any event affect the competencies of the member states concerning national security regardless of the type of entity entrusted by the member state with carrying out tasks in relation to those competencies. Okay, so it already starts here. There's a lot of hopes, but it starts crushing all your hopes. And then, this regulation does not apply to AI systems in or out of the EU market when it is used exclusively for military, defense, or national security purposes, regardless of the type of entity carrying out those activities. Again, speaking of high-risk AI, I don't know what gets more high-risk than that, but no.
So Terminator's okay. Terminator's legal.
Terminator's legal. This regulation applies neither to public authorities in a third country nor to an international organizations where those authorities or organizations use AI systems in the framework of international cooperation or agreements for law enforcement and judicial cooperation with the Union or with one or more of the member states, provided that such a third country or international organization provides adequate safeguards with respect to the protection of fundamental rights and freedoms of individuals. This is kind of laughable. Basically, we choose who are our friends, and whatever they do is fine. Also, it does not apply if you're not planning to provide or deploy whatever you're doing in the EU market. What's happening here, in effect, is that they realize there's a lot of money in doing a lot of bad stuff. As long as you're not doing it to my citizens, it's okay for you to bring the money of those things to my citizens. Okay. Now, this is the gist of what you see in a lot of summaries. The Act creates this pyramid of risk in usage of AI, and then it goes from like very minimal risk, like low or barely risk applications where the only thing you might want to do is to have a code of conduct, to things like some chatbots where there are some transparency obligations, and then you get to high-risk areas where there's a comprehensive regulation, and on top of that you have the unacceptable risk. These things are banned. So what are the things that are banned? Exploiting vulnerabilities, age, disability, socioeconomic background to distort behavior and harm. I can think of a lot of things that are considered these days as normal that fits into this. Social scoring systems causing unfair or disproportionate treatment, predictive policing based solely on profiling or personality traits, and untargeted scraping of facial images to build recognition databases. Sure. One thing to mention is that the Act is not it's the minimum bar for the member states. It's not the strictest that they can be. For instance, in this case, Denmark just passed a law where they make your voice and your face, you own them. You have like the copyright rights to your face and voice, which means it attacks all the issues with deepfake. Other member states don't have it. Germany, I think, like a very recent case came out, which is setting the precedent for it. But those areas are not regulated necessarily by the Act, and member states can be a little bit more strict. Emotion recognition in workplaces or schools, unless it's like for medical or safety cases, and biometric categorization inferring sensitive traits like race, religion, etc., and manipulative, subliminal, or deceptive AI that distorts behavior and harms people. Not too bad. But common and legitimate commercial practices, for example, in the field of advertising that comply with the applicable law should not in themselves be regarded as constituting harmful, manipulative, AI-enabled practices. But it is. Yeah. So a lot of hopes crushed. Then real-time remote biometric identification in public spaces by the police. This is the most contested banned use case of the Act. If you go to the part where it talks about prohibited practices, each case, a single paragraph, maybe some citation here, easy, yes, it's banned. And then you get to the last one, which is like, okay, like it is banned, but then if you want to do this, it's okay. But then like you should do this. And then if you do it, then you should register it like here, and then you should notify that person. You should try to do this, but if you don't have time, it's okay. And then you're like, okay, like why the struggle? Like the rest of it was pretty easy. Okay, what happened there? The struggle was because the Act was being finalized in December 23, which also coincided with Spain leaving presidency of the Council of the European Union in January 24. and Belgium was coming. And when you're the president, you set the agenda for what's being worked on. And Spain was worried that Belgium might completely shelve this whole thing. And that has happened in the past, in the EU. Also at the same time, France was going to host Olympics in 24, and they really wanted to use real-time biometric identification in public spaces for that. So they were a strong force for making this banned thing not really banned. And they had apparently like a, I don't know, 34, 35-hour marathon meeting to finalize that part of the draft. And this was what came out of it. Okay, so moving down, what are the high-risk areas? The first category are if it's a part of the safety component of something, or the AI system itself is a product listed in this annex. Pretty clear, no ambiguity really there. But the one that people really talk about is things in Annex 3, for instance, biometrics including emotion recognition, critical infrastructure cases, education and vocational training, employment, workers' management and access to self-employment, access to and enjoyment of essential private and public services and benefits, law enforcement, migration, asylum and border control management, and administration of justice and democratic processes. Sure, yes, these are all very high-risk cases. Now the question is, like, can I read that and infer that, okay, AI used in media, recommender systems, science and academia, like experiments, drug discovery, like there's a lot of issues there in terms of like representation of potential patients to that potential drug. Most of finance and trading, most types of insurance, specific consumer-facing applications such as chatbots and pricing algorithms, all of that. It feels like it should be high risk. No, these are all the things that advocates would have loved to have categorized as high risk in the Act, but none of them are. On top of that, when you have a high risk application, you have to register that before you deploy it. But you could argue internally that this is not high risk. You can have documentation which argues that no, it's like it performs a narrow procedural task, or it improves the result of a previously completed human activity, or it detects decision-making patterns or deviations from prior decision-making patterns and is not meant to replace or influence decisions that we make, or it performs a preparatory task. This exclusion does not apply to profiling natural persons. If you think this is the case, then you can document that, and then when you register your high-risk case, you say that I've done my homework, this is not high risk. You do not have to include that documentation in your registration. So the conditions for not being high risk here are pretty vague, and also the burden for checking lies on the authorities, and it's also post-deployment. You register, you deploy, you start making money, and then if somebody has time, they might come and ask, hey, what was that documentation that you said you did, which is like, you say it's not high risk. And then they might like, then have objections to that, then you might have to like take it down. In the meantime, you made a lot of money. And also, none of that is public. Okay. Another topic in the Act is that if it's high risk, you need to have a bunch of technical documentation. It's not too bad. It's like a fancy model card, general description of what it's doing, development details, design specs, etc., validation and testing, what are the data characteristics, pretty good, risk management and changes, compliance evidence, and post-market monitoring plan, like what are you doing for incidents that might come up once you deploy. This information, if shared, is very confidential. And also, law enforcement, border control, immigration, or asylum authorities, data never leaves their site. Information shared only after consultation with relevant authorities. So if you're a notified body, which is the body that is supposed to go and audit these cases, you have to get permission from these authorities to be able to audit them. It is only strictly necessarily information shared, and also these cases are not put in the public database where all the other high-risk stuff are. It feels like the actual high-risk stuff are like really just not there. And also, For everybody, if a notified body is necessary, it is an external private entity. For these cases, the public sector itself is the notified body. So even if they audit themselves, it's themselves auditing themselves. Okay, a different topic. There is a thing called human oversight. If it's a high risk, you need to have human oversight over it. Nice. And there are like different things that you need to do. One of them says the oversight measures shall be commensurate with the risk's level of autonomy and context of use of the high-risk AI system, and shall be ensured through either one or both of the following types of measures. And these measures are like the person who is the provider of the model, like the one who trained the models, either puts things in the model that are those safeguards, or lists things that are like, if you want to use it, you should do these things before actually putting it in production. Okay. And now remember, in Annex 3, the high-risk cases, we had biometrics insofar as their use is permitted under relevant union national law, and remote biometric identification systems, which is not just to identify who you are, like a fingerprint to be like, yes, this is who I am. Add to that, for high-risk AI systems referred to the point of Annex 3, the measures referred to in paragraph 3 of this article shall be such as to ensure that, in addition, no action or decision is taken by the deployer on the basis of the identification resulting from the system, unless that identification has been separately verified and confirmed by at least 2 natural persons with the necessary competencies, training, and authority. Not bad. Again, good hopes. Continues. The requirement for separate verification by at least 2 natural persons shall not apply to high-risk AI systems used for the purposes of law enforcement, migration, border control, or asylum, where union or national law considers the application of these requirements to be disproportionate. Okay. Okay. The other part is what the Act calls general purpose AI. And there is a categorization of high impact, basically high impact models. What makes a model high impact, or like a system high impact? And there are certain requirements. One of them is basically if it took you more than 10 to the 25 flops to train the model, then it's high impact. The Commission, the number is subject to change based on how technology advances, but this also resulted, I think it was Llama 2 release, where Meta was like, it was right above this threshold, and Meta was like, no, I don't know what's happening in the EU, I'm not going to release it in the EU. Partly because they didn't know what really it means to comply with this act, and partly they wanted to put pressure on the regulatory bodies to be like, no, I'm not, you're not good enough for my model. But again, here you can also argue against being high impact. You document it, you say it's not high impact, but at least here you submit that documentation at the same time as you register your model, which wasn't the case for the high-risk cases. Really, like, post-deployment check is not a usual thing in the EU. That's an oddball. But here, you can still, like, get out of it. Okay. What are the things that, in the Act to support SMEs? The regulation does not apply if the AI system or AI models, to the AI system or models prior to them being deployed. If you're just like trying to work on it, you're like testing it internally, not in the real world, it doesn't apply. Or if it's like your case is for the sole purpose of scientific research and development, or you put it like as an open source thing out there, with the exception that like very large models, even if it's open source, like some things apply. Also, if you want to test your high-risk system in the real world, there's a very nicely defined regulated sandbox where you can go test your system. As a small entity, you get priority access to them, you get cheaper trainings, you get cheaper access to the compliance costs, all of those things. And if you are like one of these cases, it is good to have an eye on your local authorities and governments to see like what they're providing. There will be a lot of training and a lot of documentation that come up. Okay. And there are 2 things really, like, Two things that are like worth mentioning that are for the private sector to come in the game and be a part of this machinery. One of them is if a non-EU entity wants to deploy something in the market, they have to have a representative. You can be that representative. You become the point of contact, you keep all the documentation, et cetera, et cetera. Not too bad. The other one is a notified body, which is the body that audits the cases and makes sure that the high-risk system is complying with all the regulation. It is independent, it does like third-party assessment, it issues EU certificate, 4-digit number beside the CE marking that in the EU we are used to seeing on all products. And member states have to accept, like you submit, you're like, hey, I want to be a notified body. They assess you. If you're good enough, you can pass all the confidentiality, like all the things, then you can be a notified body. And then you go and you audit people's work. The point here again is that it is like, our understanding was that it might be required only in biometric cases. In all the other high-risk cases, the CE marking can be applied if you do an internal audit. You don't have to pay a notified body to come and audit you. You do your internal assessment, you put the CE marking, and you're like, I'm okay, unless some authority comes and wants to like check your documentation. Which is like, you know, companies did obviously influence this act, and they're the only ones who are auditing themselves. It's not just the private sector who audits themselves. Okay, and then the last point I wanted to make is like, what's the relationship between like whole fairness and the act and GDPR? There is a part where, like in the documentation and requirements for high-risk cases, which says, examination in view of possible biases that are likely to affect the health and safety of persons, have a negative impact on fundamental rights, or lead to discrimination prohibited under union law, especially where data outputs influence inputs for future operations, and appropriate measures to detect, prevent, and mitigate possible biases identified according to point F. This is a lot of like a lot of like points made in the AI fairness space. A little bit. This was the point where like when GDPR came, and a lot of people active in the fairness space were like, okay, like if I don't have access to personal information, how can I make sure that I'm fair? Union law on the protection of personal data, privacy, and confidentiality of communication applies to personal data, blah blah, without prejudice to Article 10 and like Article 59, which means high-risk AI providers may process special category personal data only when strictly necessary to detect and correct bias, but in all other cases, they have to respect GDPR and the other Digital Thing Act in the EU. So GDPR, therefore, you can only use personal data if there is no viable alternative. You can't use pseudonymized data. You need to make sure that very specific people in your entity, in your company, have access to that data. It's never shared with third parties, and it's deleted after the retention period or when you don't need to that data to correct your algorithm anymore. But with all of that, fairness is a very contested concept. Definitions stem from ideology. Depending on how your worldview is on how the world should be or how the world is, you choose different metrics to optimize. It is mathematically impossible to optimize for all of them. They contradict one another. And there is this thing like in the fairness community that you give me an algorithm, almost no matter what it does, I kind of give you a metric according to which your algorithm is fair. So this whole space is TBD. We need to see cases coming out and seeing how the judiciary system in the EU reacts and what the cases are going to be to see how fairness with the AI Act work together. And with that, I'd like to thank you for listening to my rant.
All right. Thank you, Adrin. I'll stay here. If you have questions, remember to put them online in the best case. So far, I see one question here. Just go ahead. So it says, there's a lot of issues in this act as seen in the whole talk. A few. Do you see any good that could come from it? Or maybe a way for it to be reformed so it can actually help regulate?
So on the reform part, the reforms that are coming out, I'm not very optimistic about them. For instance, AI is kind of defined in the Act the way that it's basically algorithmic decision-making based on rules that are automatically generated from data. So most machine learning is a part of that. And then with that, I would think that, okay, even a logistic regression, it is included. But there are attachments coming to the Act where they're specifically excluding those simple algorithms. So that's on the downside. On the plus side, even before the Act coming, I was in an organization where we started doing internal audits of our high-risk algorithms because we were like, okay, the Act is coming. And people who care about these things have a lot more leverage inside companies to actually go and spend time on these things. I'm not sure, if you want to be evil, I think you can, but it has become a lot easier for a lot of us working in these organizations to argue in favor of doing a little bit of audit and check certain things that before that nobody would want to pay our time, they are to actually do.
All right, thank you. So far, I don't see another question here. Are there questions in the audience?
Thank you very much for the interesting content shared. I was exposed to this topic when I was working at healthcare, and there they looked at models as also medicine. So, and they think everything should be CE certified. And I was wondering, because you also mentioned something about CE certification, how do you see this impacting, for example, sensitive sectors like healthcare? And do you think these are strong enough regulations, or so how do you see that?
If I'm not mistaken, for most healthcare, it's regulated separately.
Okay, so this
as you say, a lot of those models are seen as a part of the whole medicine, and therefore the regulation there is a lot more strict on this. My PhD was in bioinformatics. We did have models where we could classify patients which subtype of cancer it belongs to. Every now and then, the pathologist would come and be like, hey, can I see the output of your algorithm for this case? We would give them. They would kind of use that as a consulting partner. But no way that we would have the budget to actually go through and make that a commercial application. That would require a lot more hoops to jump through. And to me, that's a good and a bad thing, in the sense that I want to have those safety nets, but the downside is there is a huge community of kind of biohackers, especially in the diabetes community, because we have such simple solutions where people don't have to keep checking their measures. They don't have to have manual interventions. The automatic pumps, you can program them for almost all cases in your daily lives, but none of those are commercially available because it's really, really hard to get the certificates for them. So it's some downsides, but when it comes to medicine, probably better safe than sorry.
Okay, thanks.
All right, one last question, then we're out of time. There's one that popped up from Andy Kitchen. I will read it anyway. Do you think it is possible to investigate fairness questions without measuring sensitive and personal data? Can you think of any use cases or examples?
Oh, you're the best person to answer that. You have a whole talk on that, I thought. Again, this question can only be answered based on the ideology of the person. To me, no. But there is a good part of the fairness community who would say yes. I care a lot about systematic oppression on groups, which also goes into the direction of group fairness and stuff. Therefore, for those ways of thinking, I do need to know who those people are to see if I'm like being fair or no. But if you change your point of view on fairness, if you go into like counterfactual and individual fairness, then kind of no. So it kind of depends on what you consider fair, really.
As always, it depends. Okay, give it up one last time for Adrin.